بسم الله الرحمن الرحيم الحمد لله وحده والصلاة والسلام على من لا نبي بعده أما بعد السلام عليكم ورحمة الله وبركاته. So I want to thank everybody for being here and for attending these talks, and it's been very useful and intellectually engaging. I also want to thank the organizers as well as Asim Padella, mashallah, Dr. Padella, despite the fact that he somewhat dismissed psychology as an empirically validated or backed discipline, or psychiatry for that matter. But, you know, we'll take the critique, and that's what this is for us to be able to be critical of one another and to cause us to think. One of the things that, so my research, I actually did together with Sheikh Maulana Bilal Ali, who is actually in the audience today, and we could only one of us could present. So because I wanted to present, we focused on doing the process of judicial reasoning when it comes to mental status considerations. I was elected to be the one that would present. I'm going to run through his segment of the paper as well, and he's also sitting in the audience. If there's any questions, you can also ask him about that as well. So the two parts of this, and the first part of it is my research questions. So we have two segments. One is, what is the role and relationship between Islamic law and mental health? And secondly, what are the processes of judicial Islamic reasoning with regard to cases with mental status considerations? Okay, let's deal with the first one. Before we start to look at the legislation by the fuqaha, I think it's important to be able to distinguish or to be able to understand the distinction between, when we think of forensic psychiatry or psychology in a secular context, between forensic psychiatry psychology in a theological context. And the reason why that's important is because oftentimes this intersect between the law and psychology or psychiatry in a secular context is usually in a courtroom. We kind of imagine a courtroom where we have a judge and an expert consulting to the court, and often has to do with the not guilty by reason of insanity plea. Okay, so that's that. But when we're looking at it in a theological context, it's much more encompassing. The reality is that it governs and legislates Islam, or the Sharia, are interactions or relationships between Allah, between us and God, the human being and God, in a ritual sense, and civil law in their interactions with other human beings, as well as in criminal liability and responsibility. So I want you to kind of get that appreciation. So now when we're talking about the role of forensic psychology in informing or helping to inform the legislation on either individuals or as a society, it becomes much more high stakes. And the central question that we're dealing with when it comes to Islamic in Islamic jurisprudence with regard to the to mental status is the issue of taklif. That does an individual bear responsibility for their actions? And oftentimes, one of the hadith that the fuqaha tend to rely on or to quote is the hadith regarding rufi al-qalamu an al-thalath, the pen has been lifted from the three, al-na'imu hatta yastayqid, the person who's sleeping until he awakes, the child until he reaches bulugh, and then the majnoon until he is cured. And so the general principle of the Sharia is that it targets the Sharia and legal responsibility is for the average person. But there's an exception to that average, the norm, the general. And there's a recognition early on, which is very important to note upon the inception of Islam, that the mental status has a legal bearing on that individual, and it impacts various different domains. This includes the following that I had mentioned: marriage, custody. We've talked about abortion. We've talked whether a person has to pray or not, for example. Are they legally responsible to pray or not? And so this is very important, especially when we're dealing with not only in official cases of a qadi, but somebody going to an imam and asking about their status, whether they're required to do something or not required to do something. And it becomes important for us to be able to consider the psychological context of the individual. So I'm not going to elaborate due to interest of time on the categories. I want to say, suffice it to say that there are a number of categories. There's 6 in the Kuwaiti Encyclopedia of Islamic Law, but there's a lot of overlap, so we've listed 3 and elected to list 3, and 3 that mainly have some kind of moral, some legal bearing upon the individual. So we've listed the following categories, and in general, we're dealing with junun. That's often the course of discussion, and that is the insanity plea, which is really familiar to forensic psychology or psychiatry, even in a secular context. So does somebody reach a certain a capacity where they lose their sense of appreciation of differentiation between right and wrong? And do they exhibit a new, beyond normal, abnormal behavioral manifestations that demonstrates that they do not have the capacity or the appreciation of their reasoning and their behavior? And we have different subtypes, whether it's temporary or whether it's permanent. And if it's temporary, then a person might be confined to, might be mandated to receive mandated treatment in order to recover and then to be able to proceed over their case at that point. So judicial reasoning, So now, how much time do I have, by the way? 10 minutes? I'm assuming 10 minutes. Huh? 9? Okay. We negotiated here. This is a psychological tactic. Give them, start high and then you negotiate lower. So the second portion of the research was, now what we did was, let's uncover the judicial process. What do the fuqaha do? How do they deal with issues that now when a person, because we just established that it is recognized in the Sharia that mental status is important to determining the status of an individual and to giving the fatwa, the ruling. So now, how do the fuqaha deal with this? What is the process in which they deal with this? And this was my question. And so what I did was I gathered, and specifically, the processes of judicial reasoning. So what are their attitudes? What is the role of experts' psychological testimony? And what is the common practice by Islamic judges today, contemporary practices? What I did was I used a qualitative methodology, and I gathered 12 jurists who were qualified that had some specialized training in Islamic law and had been active in giving rulings, either at a local level as an imam or at an official, working for some kind of legal body or council. These are the demographics. Due to the time, I'm just going to go through it. I want to share with you the results. It's a very diverse sample. Just trust me on that. We can talk about it. So the results. So what is the process by reasoning? The thing that we found is I've outlined this diagram. The process of reasoning is that when an individual gets a legal question, it's very important for them to do what? To understand the question and the questioner. That's very important. To get the scope, not only is it important for them to understand the question and questioner, but also the scope of their work. So are they acting in an official capacity as a qadi? Because that has a certain rules and protocols that are specific for them. Are they acting as a mufti who's not an official, who's more of a mukhbir, an informer of the law? Or are they acting as a murshid, as an imam, trying to guide somebody more spiritually, even though there might be legal implications of the situation? It's very important for them to consider that. And in understanding the question, they also might want to utilize, it's very important for our purposes, expert consultation to be able to understand the manifestations of the question. Is there a question behind the question? Somebody is asking a question. The fuqaha are very studious in understanding, is hijab mandatory? For example, you ask an imam, well, should I write do istidlal, write a report on this and give you an official fatwa? No, but there might be some question behind the question that's actually more important. That's more of the irshadi approach. And And so, okay, once we've determined that this is a legal question, we really have to deal with this legally. There's a mental status consideration. How do we deal with this? And I'm not going to be too redundant because Dr. Volkan, mashallah, he is also presented on this process. And the first two processes are reserved for the jurist, which is the Shatibi, which is what jurists have cited in my report, that they utilize the tanqih al-manat, takhrij al-manat. So determining, in essence, what is the legal data or precedents, and looking at the categories and definitions of all of these things. And then once they determine that, I'll give you an example. We've talked about abortion a lot. Ibn Abidin of the Hanafi madhab, for example, says that now there is precedence, there is legal basis to demonstrate that if there's significant psychological harm, ghalabat al-dhann, that's significant, overwhelming proof that there's going to be significant psychological harm to this individual, that before the ruh enters the body, then that person is absolved of responsibility if they do go through with an abortion. Now the question for our purposes now, the tahqiq al-manat, how do we determine substantial harm? Because, and it's important to note that the fuqaha have really left a lot of these categories vague enough so that there's a lot of discussion, and in the nusus it's also vague as well. It's not all categorized and outlined. So this is where the tahqiq al-manat becomes very important for the jurist, for the psychologist or psychiatrist to be able to provide expert testimony to the faqih to be able to inform that decision. It's notable, it's important to note that 100% of all participants endorsed the utilization of expert testimony. And this included imam settings, being able to refer to an expert when they weren't clear on whether there's any psychological implications on this individual. There's demonstrated precedence for this. Qualified witnesses, he wasn't a psychologist per se, but would inform the court about individuals within the community, would tell the qadi about whether this person is just, whether they're known, what their family status is, their history, their background. And I give you, I'm going to skip over this precedent. There was a precedent that was laid out, but it's very important to understand that it's also important for the jurist to translate the clinical data, because clinical terminologies of mental illness don't necessarily translate into legal categories all the time. They're not. They might be distinct. So the responsibility of the faqih is to take the data that they're giving and not to just take it as, for face value, but to be able to analyze that and translate that into a legal context. What kinds of scenarios is this useful for? All of the following. The implications are very wide. Current judicial processes, 2/3 of the fuqaha reported that they did utilize expert testimony. However, they also said that, all of them said that they utilize it themselves, but they also said that it's underutilized in our society today. That it's very rare for fuqaha muftis in an unofficial capacity for the most part to utilize expert testimony in being able to give high-stakes decisions. There's, and some of the reasons for underutilization was lack of training, lack of exposure. Sometimes there's no, in the training or the discipline, the individual has not been trained to identify particular identifiable variables that indicate that there might be something wrong with the psychological status of this individual. It might be a cursory study of the section of junun, for example, without elaborate discussion. It might be individuals who are not fuqaha proper, that have appropriate training for that, and they operate as such. There's a number of reasons that they've listed for the barriers. So what do they recommend? And I'll end on this. They all recommended that we develop a coalition or committee of clergy and mental health experts, a task force that really hammer out some standardized standards of practice, standards of care. Because even in the legal literature, there's a lot of opinions, and there's also mixing of terminology. So some people use safaha for one thing, and then somebody else will define it a little bit differently. And some people will say there's some implications for this. Some people say there's not for this. The easy ones are junoon, like somebody who is wildly insane, for example. For lack of a better word, it's kind of common colloquial way of putting this. But more sophisticated manifestations of this, such as temporary bouts of insanity. Person gets angry and divorces his wife. Well, what is that threshold in which acceptance of their psychological status is compromised? How do we negotiate and identify and outline standards of care or practice so that we can be able to highlight and use this? They've also recommended that inclusion of education training of clergy in the social and human sciences and increase collaboration, not only on an official level where we can create standards of practice, but even on an individual micro level where there's consultation on specific cases to be able to uncover and to provide a holistic response. And I'll conclude on that. وآخر الدعوانا أن الحمد لله رب العالمين.